Alright, so let's start with the facts. The Bay Mills Indian community is a federally recognized Indian tribe with a reservation located in northern Michigan. The tribe has been operating gaming in the Upper Peninsula for a few decades. In 2010, using funds from a congressionally established trust, the tribe purchased land in the Lower Peninsula and decided to open a small casino over there. The state of Michigan filed a lawsuit in federal court asking to close the casino, claiming that it violated state gaming laws and various provisions of the tribal state compact. The state argued that the casino was not on Indian lands and was therefore illegal. The district court entered a preliminary injunction ordering Bay Mills to stop the gaming at this casino. The U.S. Court of Appeals of the Sixth Circuit vacated the injunction, holding that the district court lacked jurisdiction over some of the plaintiff's claims, and that tribal immunity barred, or in other words prohibited, Michigan's suit against Bay Mills, unless Congress provided otherwise. Now I'm going to talk about the legal issues. In 1988, Congress established the Indian Gaming Regulatory Act, in other words, IGRA, in order to regulate Indian gaming and created three classes of gaming. Class 3 gaming is the most highly regulated one. It includes casino gaming, horse racing, and slot machines. According to this act, an Indian tribe can operate a casino on Indian lands if certain requirements are met, including a compact between the state and the tribe. Also, IGRA allows a state to bring a lawsuit against a tribe for certain compact violations. The compact between Michigan and Bay Mills Indian community was made in 1993. The issue before the court was whether Michigan was allowed to sue Bay Mills against the based on IGRA. Michigan's opinion was that it could sue the tribe and close the casino. Bay Mills insisted on sovereign immunity and argued that the lawsuit could not proceed based on that doctrine. In this case, sovereign immunity means that Indian tribal governments cannot be sued unless they are sued by the federal government, they absolutely agree to be sued, or Congress has explicitly stated that they can be sued in a specific context. In a larger context, if the Supreme Court was to uphold the ruling in prior case Kiowa Tribe of Oklahoma versus Manufacturing Technologies regarding the regulation of business activity of the reservation lands, then according to stare decisions, they would rule in favor of Bay Mills. Their other opinion is they could rule in favor of Michigan, rationalizing the casino wasn't on reservation land and therefore was not covered by IRGA.
All right, so I'm going to be talking to you about the decision the Supreme Court made. Their actual final decision on a 5-4 basis with with the majority opinion, a concurrence, and then 3 different dissents. So the decision that the Supreme Court itself made is that the suit is not allowed to happen because the law grants tribes sovereign immunity on this subject. Now, the majority opinion was written by Elena Kagan and joined by Justices Roberts, Kennedy, Breyer, and Sotomayor, with the agreement stating that the agreement between Bay Mills and Michigan specifically bars suits because of tribal sovereign immunity, which is not abrogated in this compact. Now, furthermore, the suit is barred because the activity takes place off Indian land, and the law in question here only allows suits for activities that take place on Indian land. And to elaborate on this, the Interior Department, who actually runs all things tribal, has said that land purchased with tribal money isn't actually tribal land, it's just land that was purchased with tribal money. So, since Kiowa, Congress has looked at tribal immunity and decided to leave the status quo as is. And furthermore, the majority holds that it is not up to the court to change the will of Congress and make dramatic changes to tribal sovereign immunity. Now, this is because, of course, that this immunity exists explicitly unless Congress takes it away. Furthermore, the state has other remedies at its disposal, such as suing the individuals involved. And the contract includes an arbitration clause for disputes that Michigan and Bay Mills can resolve amongst themselves. Now, there are a few big points to take away from the majority opinion. First off, to quote Kagan, there is sometimes a difference between the right to demand compliance with state laws and the means available to enforce them. Now, the second big point is that tribal immunity is only for the federal governments to take away, and it is not this is not a power that is left up to the states. And finally, unlike states, tribes did not waive their immunity from suit at the Constitutional Convention because they were not invited. Now, to discuss the concurrence that was written by Sotomayor, this further elaborates on why tribal immunity should be protected. Specifically, she argues that the dissent views tribal immunity somewhere between foreign and state immunity, and that it is simply too esoteric to be applicable here. And she further argues that tribes have been less successful economically than the dissent seems to believe that they are. Now, the primary dissent comes from Thomas and joined by Scalia, Ginsburg, and Alito. And this rests on two principles. The first being the idea of immunity and Congress. The idea that tribes are domestic dependent nations who maintain some, in their view, vestigial sovereignty. Essentially, they believe that tribal immunity is only a thing because the federal and state governments allow this to exist. They further believe that Kiowa was a disastrous decision that gives states an overwide definition of commercial immunity that they're being forced to work with. These four believe that the tribe should only have immunity within their own courts, and they should not be able to use it once they leave their reservation. Furthermore, they believe that immunity should only be handled by Congress, and as Congress has made no major decisions on the subject of tribal immunity, the court is simply making this up. There is a second part to their dissent with the doctrine of stare decisis, and the idea that while in general, previous decisions should stand, the economic situation of many tribes has changed dramatically since Kiowa, and this means that the original purpose is no longer as relevant, and this is because many tribes now regularly engage in off-reservation economic activity. Now, there was a second dissent from Scalia, who argued specifically that tribal immunity is essentially a judge-invented concept and is going bigger than anyone ever intended, and he personally would like to reverse his decision on Kiowa given the opportunity. And the final dissent was from Ginsburg, dissenting from the dissent, arguing that not only tribal immunity, but perhaps state immunity itself has been allowed to get overbroad and be used in simply too many contexts.
Federal government. Michigan analogizes tribal immunity to foreign sovereign immunity, which is generally not immune from suits arising from commercial activities. However, Indian tribes have never historically been recognized as a foreign government in federal courts, even when they requested to be. As it is, Indian tribes exercise inherent sovereign authority that is subject to plenary control by Congress. In this way, Indian tribes have more freedom over commercial activities than foreign countries regarding business transactions in the United States. We concur with the majority and believe the court correctly ruled on the side of Bay Mills. Citing IGRA, Kiowa Tribe of Oklahoma, and stare decisis, the Supreme Court held consistent with past rulings and allowed Bay Mills to operate off-reservation gaming activities because the casino was authorized, licensed, and operated from within the reservation. Interestingly, dissenting Justice Scalia was part of the court that 16 years prior had ruled in Kiowa, which he now motions to overrule. Due to a lack of substantive basis for the extension of tribal immunity for off-reservation business and permitting immunity for tribes off-reservation acts represents a substantial affront to states whose sovereignty is guaranteed by the United States. whereas tribal sovereign immunity is not. Justice Scalia also questions the ethical implications of tribal immunity in off-reservation business, and immunity can harm those who are not aware of dealing with a tribe, who do not know of tribal immunity or don't have a choice in the matter. This also applies to the areas of business that Indian tribes now exploit, which have been previously heavily regulated. For these reasons, we are of the opinion that in some eventuality, Kiowa will be overruled, or the federal courts will not adhere to stare decisis. In matter of business policy, the ruling seems to put state businesses at a disadvantage to tribal business. Tribal sovereign immunity in commercial activities opens Indian tribes up to break contracts, cut corners on typically highly regulated areas of business, or other types of business misconduct with no repercussions. But Bay Mills v. Michigan didn't create this precedent. It merely upheld the ruling of Kiowa, so in this case didn't change much on the grand scale of business policy, except to enable Bay Mills to open the Vanderbilt Casino on land it had purchased in Michigan's Lower Peninsula. Regarding effects on the general public, they'll have access to a new casino, and new jobs will be created in the area and for Bay Mills Indian community. There will be a shift in the community surrounding the casino. Per a study published by the Federal Reserve Bank of Philadelphia in 2010 called Economic and Social Impact of Introducing Casino Gambling, jobs created by the casino will displace existing economic activity. Evidence suggests casinos bring positive fiscal results to the state in which they operate, but can have a negative impact on the immediate community, such as increased taxes, a loss in jobs from the overall region, economic disruption of other businesses, increased crime, and large social welfare costs for society in general and government agencies in particular. The ethics of tribe immunity and off-reservation business were brought to light, but no one addressed the ethics of having ravaged a foreign nation with disease and warfare and taking their resources. It's a separate issue, and one could say that the devastation of Native American peoples was set in an entirely different context, but to argue ethics on a large scale in reflection of all of the injustices endured by Native American nations, by the U.S. government, and prior, maybe we can let this one slide. The Supreme Court should revisit previously signed treaties and explore the intricacies of tribal sovereign immunity in light of pre-existing legal framework. This would absolve some of the confusion regarding Indian tribe commercial conduct.